My name is Jenna Macnair, and I'm an associate at the Nashville law firm of Macnair & Harrod. I'm going to talk today about who qualifies as an employee in the context of modern fidelity bonds and commercial crime policies employee theft provisions. Through today's presentation, we are going to review the more common employee definitions found in today's fidelity bonds and commercial crime policies. We'll also talk about how courts have interpreted employee definitions over time and important factors used by the courts to evaluate whether a wrongdoer qualifies as an employee. And as we go along, we'll discuss recent case law concerning those employee definitions and how they may impact courts' analyses going forward. The term employee has developed in the law to generally include an element of direction or control. Black's Law Dictionary defines an employee as someone who works in the service of another, the employer, under an express or implied contract of hire, and the employer generally has the right to control details of the person's work performance. The source of this control language is likely based in the common law agency doctrine's master-servant relationship, which has been relied upon by courts in a variety of settings in the absence of specific statutory or contractual language. The primary element used to determine whether an individual is an employee under the general common law of agency is whether the hiring party possesses the right to control the manner and means by which the employee accomplishes his or her work. In the context of financial institution bonds and commercial crime policies, determining the appropriate employee definition always begins with the policy language itself. So we'll start by looking at some of the more common employee definitions found in modern policies. First up is the Surety and Fidelity Association of America's Standard Form Number 24 Financial Institution Bond. The 1986 version is extremely common and defines an employee in part as an officer or other employee of the insured while employed in, at, or by the insured offices or premises covered hereunder. In 2004, this form underwent significant revisions, including to the definition of an employee. The 2004 version defines an employee in part as a natural person while in the service of the insured, who the insured has the right to direct and control in the performance of his or her duties, and whom the insured directly compensates by wages, salaries, or commissions. The key change I want to highlight here is the inclusion of direct and control language in the 2004 revisions. This change mirrored language already adopted by other fidelity coverage policies and effectively codified then existing case law. As we'll talk about on subsequent slides, a lot of courts were already evaluating the insured's right to control as a key factor in determining whether the individual is a qualified employee. As a final note, there are additional subsections to both of these employee definitions, which include, for example, persons provided by an employment contractor or agency to perform employee duties, guest students or interns, and any directors performing acts within the scope of the usual employee duties. Turning to commercial crime policies, the 2005 Insurance Service Office Commercial Crime Policy is one of the more common policies currently offered. Its employee definition includes any natural person while in your service and for the first 30 days immediately after termination of service, unless such termination is due to theft or any other dishonest act committed by the employee. This natural person needs to be someone that the employer compensates directly by salary, wages, or commission, and someone the employer has the right to direct and control while performing services. Like the 2004 Financial Institution Bond, this language includes both the direct and control factor and requires that the individual be compensated directly by the employer, which is another factor we'll talk about in subsequent slides. The key factor in determining whether an individual qualifies as an employee is whether the employer has the right to direct and control the manner and the means by which the individual accomplishes their work. By way of example, in GRM Management, a 2017 decision out of the Eastern District of Virginia, the hotel insured engaged with a subcontractor to perform casual labor and maintenance services. The subcontractor caused a significant loss resulting from theft of personal property and materials, and the insured sought coverage under its employee theft policy. That policy defined an employee as any natural person in the insured service who the insured compensates directly and who the insured has the right to direct and control while performing services. The district court concluded that the subcontractor was not covered because the insured may have directed the ends of his work, but not the means by which his work was conducted. Some of the factors the court considered were the subcontractor's considerable flexibility in performing work and his lack of supervision, the absence of a weekly hour requirement, his project-by-project workload, the use of his own resources to complete projects and ability to do so off-site, and his ability to maintain outside employment. Insureds can rely on this control analysis to successfully defend against coverage claims where an owner wrongdoer so dominates the insured that the insured exercises no control over him and he instead becomes the insured's alter ego. For example, in Retailer, the insured's shareholder and chairman misappropriated $87 million from the insured corporation, who later sought coverage under its employee dishonesty provision. The bankruptcy court determined the majority shareholder's actions were subject to the alter ego defense. The court noted that allowing the insured to recover for what was essentially its own fraudulent acts would go against public policy, where fidelity bonds were clearly designed to insure corporations against employees' dishonesty acts and not their own dishonest acts. In the 2011 tactical stop-loss decision out of the Eighth Circuit, the insured CEO, who was an excluded officer shareholder, stole funds from the insured. The COO, who was not a shareholder, later discovered his theft but decided to help conceal and continue the theft in exchange for a financial reward from the CEO. The Eighth Circuit stated that even if the COO partially caused the loss, she did so by participating in the theft with the CEO, and the officer shareholder exclusion excluded loss attributed to the CEO and others colluding with him. While modern bonds generally incorporate direct and control language, and courts have relied heavily on the bond's express terms in determining coverage issues, bonds and policies without express direct and control language have forced courts to look elsewhere, with somewhat incongruous results. When the dishonest employee is a regular non-officer or director employee, courts tend to read in direct and control language to their analysis. However, when a dishonest officer or director is involved, the courts rely more literally on the policy language and definitions. For example, in Arrowwood Indemnity Co., the insured student loan lender sought employee dishonesty coverage under its financial institution bond, where its founder and CEO and sole shareholder used the insured as a Ponzi scheme for his personal enrichment. The bond defined an employee, in pertinent part, as an officer or other employee of the insured while employed in, at, or by any of the insured's offices or premises covered hereunder. Because the bond's definition of employee included officers and did not expressly require that the insured have the ability to control and direct the individuals, the court concluded the wrongdoer officer was covered under the bond. In fact, the court leaned into its strict contractual interpretation of the bond in rejecting the insured's alter ego defense, explaining that where the intention of the parties as to who are employees is expressed in a fidelity policy, that intention will be given effect, and an alter ego defense asserted in the context of a fidelity bond is therefore not a common law defense, but rather it's a defense derived from the language of the policies themselves. While the key factor in this analysis is the employer's ability to direct and control, there are other factors the court will consider, including the individual's compensation. The wrongdoer generally must be compensated, and that compensation must be direct. For example, in Chansey, the insured was a dental practice, and the dentist's wife caused a significant loss when she incurred $300,000 in credit card debt on behalf of the practice and stole $25,000 from the practice. Although the wife performed duties as the practice's office manager, her position was not paid, and the district court determined she was not an employee for coverage purposes. It's not always enough that the wrongdoer be paid, as they must also be paid directly. For example, in TSI Holdings, the wrongdoer director of what we'll call Entity A misappropriated Entity A's fund. The director was paid by a related entity, we'll call them Entity B, which performed work for Entity A and received management fees from Entity A, which included a component for the director's work. Even so, the court found the director was not paid directly by Entity A, and so he was not an employee who was receiving direct compensation for coverage purposes. When faced with dual employment situations, courts have had to parse the wrongdoer's behavior in his capacity as an employee versus that of a non-employee. Courts have generally found that an individual's non-employee status does not impact coverage for dishonest actions undertaken in his employment capacity. For example, in Greenwald, the insured company employed a business and financial manager who, in addition to working for the insured professional corporation, acted as the neurosurgeon's personal assistant and was responsible for managing his real estate company. The financial manager's separate duties, coupled with his theft scheme, raised issues regarding who was an insured under the bond and what losses were covered. The court ultimately held that the only insured under the bond was the professional corporation and not the neurosurgeon individually, nor him in his real estate capacity, and the professional corporation could therefore only recover losses that it sustained while the employee was acting in the ordinary course of business for the professional corporation. Issues have also arisen where an employee's theft or other wrongful behavior takes place outside of normal business hours. Courts here have found that these off-the-clock employees are still employees under the insured's bonds, where the ordinary layperson would regard them as employees after quitting time, just as they would during the employee's workdays. In the 2015 Union Hill decision, the court took things arguably a step further. There, a former part-time employee helped facilitate the after-hours robbery of a pharmacy by supplying the robbers with a key and security passcode to enter the premises. Even though the only employee involved was a former and part-time employee, the court held that she used her knowledge acquired as an employee to facilitate the theft and therefore qualified as an employee under the bond. There may be a limited exception to an employee always being an employee, where the individual's employee status is more casual. For example, if they're a handyman who performs irregular work and they're paid at the close of each business day, they're effectively hired and terminated after each day worked, and so may not be considered an employee after business hours. In today's gig economy, reliance on independent contractors is high. Infidelity bonds and commercial crime policies lacking express inclusion or exclusion of independent contractors, courts have had to continue to rely on the direct and control factor to determine whether an independent contractor is an employee under the policy. To drive this home, we've included as an example the third federal savings case from the Sixth Circuit. There, the bank contracted with a real estate appraiser to provide inspection reports, and the bank eventually suffered a loss due to the appraiser's fraudulent reports. There were a lot of factors that suggested the bank and the appraiser's relationship was something other than a typical employer-employee relationship. The appraiser lacked set work hours, he was paid on an agreed-upon sum per appraisal, his withholdings weren't deducted from his payments, and he paid his own expenses. The court acknowledged all of these red flags, but expressly relied on the lack of control factor to determine that the appraiser was not an employee under the bond. Perhaps in response to the growing number of independent contractors performing services in today's workforce, insureds have increasingly attempted to include independent contractors in their policy's employee definitions with varied success. For example, in Jerome Group, a subcontractor defrauded the insured by billing and receiving payment for services never performed. The insured argued that the subcontractor was an employee under its policy, which defined an employee as a natural person who is in the insured's service, compensated by the insured directly by salary, wages, or commission, and directed and controlled by the insured while performing services for the insured. The district court held that the subcontractor corporation was not a natural person and so did not come within the scope of the policy's employee definition. With regard to the subcontractor's principals, the court determined they were just independent contractors and not employees. More recently, in Colony Tire Corp., another district court determined a contractor's principals were employees for coverage purposes. There, a payroll services contractor controlled by two brothers defrauded the insured client. The insured's policy included in its employee definition contractual independent contractors, which the policy defined as a natural person while in the regular service of the organization pursuant to a written contract between such organization and either the natural person independent contractor or another entity acting on behalf of the natural person contractor for services. The court held that the brothers here were natural person independent contractors pursuant to their contractor entity's contract with the insured, and the contractor entity acted on behalf of the brothers to facilitate their embezzlement. The court's interpretation here was arguably very broad, given that any independent contractor entity necessarily has natural persons performing services for it. Many modern policies have addressed temporary or leased personnel by expressly including them in their employee definitions. For example, the 1986 financial institution bond includes a person provided by an employment contractor to perform employee duties for the insured under the insured's supervision at any of the insured's offices or premises covered hereunder. The 2004 financial institution bond includes a natural person while in the service of the insured with whom the insured has the right to direct and control in the performance of his or her duties. and who is compensated by an employment agency, which is paid by the insured for providing the person's services for work at or in the insured's offices or premises covered hereunder. Both of these employee definitions contemplate coverage for temporary or leased employees who are paid by an employment contractor or agency but not controlled by the insurer. Note too that these definitions contemplate only temporary or leased employees working at the insured's location. And as a final note, the terms employment contractor and employment agencies as used in these bond forms are often undefined terms. Courts have at times reached inconsistent results when considering similar terms inserted in employee definitions to include temporary or leased personnel. For example, in Mansion Hills, the Insured Condominium Association contracted with a property management organization to staff its on-site office. An office employee paid by the property management organization, but under the daily supervision and control of the insured, embezzled funds from the insured, and the insured sought coverage under the employment dishonesty provision of its business and property insurance policy, arguing its property management organization qualified as an employment contractor, which was expressly included in the policy's employee definition. The court ultimately held the term was ambiguous and construed employment contractor in favor of coverage, explaining that there is no substantive difference between the insured paying a recognized temporary services agency, who in turn pays a worker to serve as its office manager, and paying the property management company here to staff the position and do the very same thing. Just 1 year earlier, the Ninth Circuit reached a different conclusion in Vaughn's Company. There, the insured grocery contracted with another company to purchase goods on a secondary market. When the company's employee embezzled funds from the insured, the court rejected the insured's coverage claim, which was based on an argument that the other company qualified as an employment agency, which was expressly included in the employee definition. The Ninth Circuit rejected this argument, explaining that the company was not an employment agency or its equivalent, where it had not been contracted to provide the insured with personnel per se. Notably, the 2004 financial institution bond replaced the term employment contractor with employment agency. This change may have been made in part as a response to the Mansion Hills and Vaughn Company's cases. More recently, in Telamon Corporation, the district court considered a third term, labor leasing firm. This case involved a crime policy that defined an employee as including a natural person who is leased to the insured under a written agreement between the insured and the labor leasing firm and subject to the insured's direction and control. The insured's vice president used a separate business entity to execute a consulting agreement with the insured in which her entity was tasked with reselling the insured's unused equipment, and she was identified individually as an independent contractor. The VP converted the sales funds for her own use, and the insured sought coverage under its commercial crime policy. The court found no coverage because the insured and the VP's entity were not engaged in a labor leasing relationship. The court also noted that the VP was instead an independent contractor and therefore specifically excluded from coverage under the policy's employee definition. Although the policy at issue in Telamon incorporated different terms compared to the 2004 and subsequent financial institution bonds, the case supports the general idea that a consultancy or third-party contractor not engaged in providing personnel per se may not qualify as an employment agency under modern fidelity policies. As a final note on who qualifies as an employee, some policies expressly include attorneys in their employee definitions. Notably, commercial crime policies generally do not cover outside attorneys retained by the insured, but financial bonds often do, so long as the attorneys are retained to perform legal services for the insured. The important thing to keep in mind here is whether or not the attorney is performing a legal service as opposed to business advice, for example. This can become difficult to evaluate, especially in the title services context and things similar to that, so keep in mind that these cases are determined on a case-by-case basis. The last thing we're going to talk about is the authorized representative exclusion. This is a common coverage exclusion in fidelity policies. The term authorized representative is often undefined, so courts have relied on dictionary definitions to determine that the exception's plain meaning excludes a person or entity that has been empowered or permitted to represent another in some capacity or act on another's behalf. A common example of an authorized representative is a payroll processor who contracts with the insured to withdraw and disperse payroll funds and taxes. For example, in Southern California Counseling Center, a payroll processor misappropriated the insured's funds, and the court held the payroll processor was not an employee because it fell within the policy's authorized representative exception. The payroll processor was authorized to debit the insured's account, and the fact that it misused those funds did not negate the fact that it was authorized to withdraw and handle them in the first place. The court noted that the purpose of the exception is to place the onus of vetting the individuals and entities with whom the insured engages to stand in its shoes, and thus the risk of loss stemming from their conduct squarely on the insured. In summary, I hope what you've learned from today's presentation is that control remains the hallmark of an employer-employee relationship. There are other important factors, including compensation and the employee's capacity at the time of loss, and keep in mind that non-employees may qualify as employees under the express terms of the policy or on the basis of the insured's control. Finally, parties who otherwise would be considered employees may not qualify if the loss occurred while that person was empowered to act on the employer's behalf. If you would like to know more about the information discussed in this presentation, you are welcome to reach out to me, Jenna Macnair, or any of my colleagues at Macnair & Harrod. Thank you, and I hope you enjoyed the presentation.